Good afternoon, everybody. Welcome to Data Protection for Beginners Part 2. My name's Dave Dutton. I work on the personal data breach team. You may have met me in Part 1. I deal with personal data breaches over the phone and online.
Hello, and my name's Flynn. I work in business advice, so I give small businesses like yourselves help over the phones and everything else. If you've happened to have called us over the last few years, there's a good chance I would have helped you with your inquiry.
Hi, my name's Dan, and similar to Flynn, I'm a case officer on business advice, so that's the sort of thing I do. You probably heard way too much of me in the last workshop, so don't worry, you won't hear from me until pretty much the end today, or this time.
Hi, I'm Olivia. I work on the registration team. In my role, I help organizations with the data protection fee.
So in Part 2, we're going to look at our top tips for getting data protection right first time, including stronger practices, what data protection is and isn't, staying organised, and where to go for help. Questions will be answered at the end as they were in Part 1. Over to you now, Flynn.
Thank you, Dave. So to get started with our first tip, it's know what data protection covers and what it doesn't. So GDPR has been wrongly blamed for many things since it was introduced in 2018. A common misconception is that data protection prevents businesses doing many different day-to-day activities, and this is simply just not the case. You may be familiar with phrases like, we can't do that because of GDPR, or data protection won't let us. Phrases such as these, they don't mean much on their own and are likely not to be based on the legislation if the person that's telling you those phrases aren't able to elaborate on them. This is because it is actually rare for data protection to prevent any core, basic, or business as usual processing, because fundamentally, data protection is not about stopping or preventing processing, but rather it is making sure that that processing is done in the right way. So does data protection stop you collecting certain information? No. Although some information definitely may be harder to justify than others, it's actually rare that data protection makes any information automatically out of bounds. Does data protection stop you sharing information with other businesses or business partners? Absolutely not. Allowing responsible data sharing is a key part of data protection law. And does data protection stop staff working remotely while outside of the UK? No again, as this is not an international transfer because the information or personal data remains in the business and is not being shared to another organization. This means it's very much business as usual security and information governance as if they were working remotely in the UK.
So I'll briefly touch on legitimate interest and consent, as they're the most used basis for data sharing, and in particular looking at service emails and marketing emails. We touched on this in Part 1 around consent, and employee gifts or cards, looking at legitimate interest. Data protection does not prevent you from sending service emails. Think about large retailers. They don't ask for consent when sending confirmation emails or updates on an order. This is because the emails do not contain any marketing material at all and are purely informing the customer about orders placed within the organisation. This type of email can often be sent using legitimate interest as a lawful basis, but only if the service email contains no marketing whatsoever. Also, data protection does not stop you sending an employee a gift or a card for Christmas or the birthday. It's not always practical for a small business to ask for consent. They may want the gesture to be a surprise. Again, the use of legitimate interest may be applied here, as long as there is a minimal privacy impact on the member of staff. This means doing things in the right way, taking a common sense approach. It may be inappropriate for a manager to know an employee's address, so the sensible and appropriate approach would be for HR or the person responsible for staff records to make delivery arrangements.
And I think those examples that Dave has just gone through do show that data protection is about protecting and upholding people's rights, but it does not encroach on your ability to do business or usual processes that have a minimal privacy impact. In fact, data protection enables you to practice good business that comes with many benefits that I hope that will become clearer throughout the rest of our workshop. So on to our second tip. This is ask the right questions and know your processes. So to better equip you to think about data protection in the right way, we have a set of questions we recommend you are asking or thinking about when starting a new project, creating procedures, handling a request, or even entering into a data sharing agreement. These are key ideas that pop up throughout data protection law and questions I commonly rely upon while giving guidance on the phones. Dave is going to come in after each question with an example that will follow through along with the questions and hopefully bring it a bit more to life for you guys. So the first question is, what is the purpose for this processing? Or in other words, why are we even doing it? This may seem very obvious, but you may have experienced how sometimes you can get lost in the practicalities of a project or implementing a certain process. This is why it is very important to always simplify and just go back to the start of why you are doing this and have that clearly in your mind.
So, for example, a clear purpose would look like the following. Manufacturing business needs to monitor employees working with heavy machinery to check staff are operating in line with health and safety policies and reduce risk of potential harm to staff.
So Dave there's just outlined a very clear purpose. Once that's done, you move on to the second question, which is what personal data is necessary to achieve this purpose? So identify exactly what you need and be able to explain why you need it, linking it clearly to the purpose you have already outlined. A good exercise here is to separate that absolute essential information, the ones that's going to make it work, from the nice to have information that may make it a bit better. Because do not forget, you should always be approaching any processing wanting to process the least amount of information possible.
Our manufacturing business identifies that they needed information of an incident reports and an account of staff practices for the processing to work. They decided they would either have a health and safety rep present watching over staff, or it could be useful to install internal CCTV to monitor staff activities with operating the machinery.
Yep, so now our business, they have a purpose and they have the ways they're thinking about achieving that purpose. So then they go on to ask, is this a proportional amount of personal data to use? Or in essence, it's kind of like a review stage. Is the amount of personal data you would like to process a reasonable amount to use for the purpose you've outlined? You will have done yourself a huge favor here if you've already separated out that essential and nice to have information, as this is where you can consider if that nice to have information can be used or obtained.
So after considering the installation of CCTV on the manufacturing line, our business decides to rule it out. One issue they identified was a CCTV would capture a lot of information that was not relevant to the purpose that outlined. They concluded that monitoring their employees in such an all-encompassing way was too privacy intrusive. On balance, they decided CCTV monitoring behaviour would be against their staff's interests and cause mistrust in them as an employer.
So then once that's been done, you move on to that fourth question to think about, and that is, are there any alternatives to what you are proposing? Consider these alternatives with a simple pro and con approach. Are there other alternatives that could maybe be more practical to implement, or are there more alternatives that have less privacy risks?
This left our manufacturing business thinking about hiring a health and safety rep to be on site at all times. However, an alternative could be to use a team leader who could be making observations as part of their role. They could report back to the manager, who could compile a weekly report from the observations on whether health and safety policies were being adhered to.
And sometimes those alternatives can be both more practical and less privacy intrusive, and sometimes a bit simpler. So then once that's been done, the last question you should be asking is, what is the impact or effect is there on the people whose data you are using? Yes, this should always be in your thought process from the very start, but it is useful to have a final review of the effect on the people's involved to guarantee minimal privacy risk. Here, think about it from their point of view. Is this too invasive? Are they likely to object, and why? Is there any detriment to them because of this processing? Is it even within their reasonable expectations? Questions like these will help you identify practices to mitigate any concerns and finally shape any processing.
So our business then went on to justify that it would be within the employees' reasonable expectations that management would be keeping an eye on them to ensure health and safety policies were being followed. Therefore, they produced a privacy notice that explained the new process and informed all factory floor workers. The business could justify their management team will be able to limit the data captured to only what was relevant, and doing so, in doing so, it was transparent.
Yeah, no, exactly. And that was by the use of these questions that will definitely help shape your practices to any use of personal data and add value to your business. Yes, it's always better to document your any thought process, but try to become familiar with asking yourself or colleagues these kind of questions that you see now, as it will really help you shape your practices on a day-to-day basis, forming them to be more understandable and clear, as well as more streamlined and effective.
Now, tip number 3, trust your instincts. If it feels wrong, it probably is. We say this because your instincts don't tend to be wrong. It takes time to develop a strong instinct around data protection. Start by putting yourself in people's shoes and consider if the data was my data, how would I feel about it being shared with other people? Or how would I feel being asked to provide health data when it's not clear why? Or even how would I feel if it was my data disclosed to someone I knew?
This is because a lot of basics of data protection law is putting some kind of common sense practices into a form of legislative language. If you find something that crops up that doesn't seem right, it's highly likely there are going to be provisions to help address any concern you have within the legislation itself. So moving on to an example of trusting your instincts is when processing a subject access request and you have information that references other people, otherwise known as third parties, the legislative language. If your instincts are telling you something may be wrong, then chase up on it and don't ignore that instinct. Why do you think this might be unreasonable to share? Do you owe that third party any confidentiality? Document your reasoning and then take a look at it and consider it if it is enough to be a compelling justification and that you are confident you could reasonably rely upon it. And there is no legal trickery here. Deciding whether or not to disclose can be very common sense and is very context specific, so you will always be in the best position to decide whether to redact or not. And remember to save a copy of your reasoning.
And this works the other way too. If you're looking at basic or straightforward information and your instincts are telling you that there should be no issue disclosing the data, you may not need to redact it. Maybe it's information that the person already seen or received. If that's the case, it does not make sense to redact out the information of the person who sent it.
So moving on to a slightly different scenario, it may be more appropriate to look at the exemptions that exist within data protection law. Now, exemptions stop you having to comply with the data protection law in very specific circumstances. So in areas where your instincts maybe are telling you to share information, but not tell that person you're sharing it, or maybe where you need to not provide certain information in a subject access request, that is not third-party data, you will find your legislative language that will allow you to do this within the exemptions. So one of the exemptions is the crime and taxation general exemption. This one is generally used for providing information to the police because data protection law does not stop you sharing information for the investigations of crime when it is for a legitimate reason and the information is necessary and proportional for any kind of investigation. However, it's not exclusive to the police. It's firmly within the realms of possibility that this can be used by other organizations. And it's also important to note that though this exemption cannot be used in civil cases, it must be related to a criminal offence.
Another exemption you should familiarise yourself with is information is requested disclosed by law or in connection with legal proceedings. In all cases when relying upon an exemption, you need to be able to justify it if and when challenged. This means that the organisation that is requesting the data from you must satisfy any questions you may have to enable you to justify the use of an exemption. Trust your instincts if you feel unsure or concerned, and remember you have every right to push back and raise any queries you have. Only disclose if you are completely satisfied with the responses you have from the organisation.
No, exactly. And it's always important to be proactive as well. Always keep an internal record of any decisions that you have made, because once you begin listening to your instincts, you will find that you'll really begin to develop a strong data protection instincts. This will help you deal with requests quicker and while protecting your reputation by maintaining the privacy interests of all parties. So now let's put your data protection instincts to the test. You should see a little poll pop onto your screen now. It's basically a little scenario that you'll see on your screens as well. And this is not meant to catch you out in any way. It's just answer it based on your immediate instincts. You can all begin to vote now on the platform while I read it out. So with a simple yes or no, do you think that this business responded the right way to this request? So the owner of a small independent shop is talking on the phone to an unhappy customer who has received marketing materials they didn't want. The customer is particularly distressed because the marketing materials related to a sensitive health matter. The customer asks the shop owner to tell them what else they know about them, and after confirming they'd like this in an email, the customer hangs up. Although the shop owner is aware that customers have a right to know what information is held about them, since this request wasn't made in an email, the shop owner decides to ignore it. So if you just answer in the poll, yes, did they answer and responded the right way, or no, did they not? Just do it based purely on your data protection instincts. So I think that's enough time if we close the poll. And we're just going to wait for the results to come through, see how all you guys did. Don't worry if you didn't get it right or anything like that. Well, that's good to see. A whopping 94% of you said no, they did not act correctly. This is because I'm sure, as most of you are aware, requests can be made verbally over the phone or in person, and it is the organization's responsibility to make a record. So well done for putting yourselves in the other person's shoes, requesting that information and what they're expecting. For those 6% that got it wrong, don't worry, keep working on it, and those instincts will really begin to develop.
Thanks for that, Flynn. So tip number 4 is keep it simple. If you can simplify your process, you reduce risk and are less likely to run into issues. This benefits everyone, particularly your customers, who will be better understand what you're doing with their personal data. For example, if your processing is relatively straightforward, then your privacy notice will reflect this and make it easy to understand. If people understand what you're doing with their data, the better it reflects on your business and the more confidence that they have in you collecting their and using their personal data.
And also this idea of simplicity, it will really help you complete subject access requests quickly and correctly. This is because their request, it might be simpler than you think. They might only be looking for a specific piece of information or data. So when you do get a SAR and it's very vague saying, I just want everything, it's worth considering clarifying with that person what they need or what they want to see. It's not helpful for you or them to try and put together a response which includes absolutely every piece of data you've ever captured on them, if that's not what they need. If you have any questions on this, definitely put them into the chat now and keep those questions coming in as we go on, and we will address as many as we can at the end. So moving on to our 5th tip, stay organized. Remaining organized is a key tip that will greatly help you deal with requests quickly, action business processes efficiently, and help ensure you do not trip up with data protection. But how do you go about achieving this? We've identified 3 parts to this, and the first part is stay on top of your online security. Now, there are some very simple steps you can do to make your information less vulnerable to cyber attacks. You could even do it at the end of the conference today. First thing is to set user accounts with strong passwords and configure all of your devices to lock when left for a certain period. Then consider your router, either when working from home or at your business. Change that password to something stronger as well. Next, you should also be getting some antivirus software and ensuring it is up to date.
So tip 2, know what information you hold and where and what you do with it. For anyone who was in part 1 of these sessions, Dan talked about the importance of knowing what information you hold, where you hold it and what you do with it, as being an integral element of being accountable. When you organise data consistently, store it safely and in a way that enables you to retrieve it quickly, you'll save yourself time in the long run. For example, if your systems are organised with everything you hold on individuals by full name, email address, contact number, etc., it will be easy to locate and access information efficiently. Obviously, in that scenario, you need to also make sure that you're accessing the right person's information, because sometimes you can get the same name, so you need to do more than one search element for that. Also, think about whether you need to hold all data as personal data. Is it worth anonymising it by removing the name or other identifiers? This is useful if you're keeping information for general business statistics only. Holding on to information you do not need creates more issues for you. It makes you less organised, slower to act, and increases security risks.
And then the third part of this tip is to always be methodical. If you approach data protection methodically, you'll find it goes much more smoothly for you. So let's take the example of subject access request again. A subject access request, it does not need to overwhelm you and shouldn't do if you work through it methodically. Break it up into the different actions you need to do. First, maybe identify what is the personal data. Secondly, collect that information. And then third, consider any third-party redactions or exemptions that might apply. Do not try to do everything at once. This will only slow you down and take up more of your time. Such a methodical approach should be taken to all aspects of data protection, and it will make it far more easier for you. And that moves us on to our sixth tip, which is don't panic if things don't go to plan. When things do go wrong, or maybe you make a small mistake, it is important to act quickly, respond reasonably, and learn something from it. Now, of course, every issue is different and has different levels of consequences. However, it is always key to always act quickly to help to stop what might be a small issue for your business growing into a far larger problem. So when responding to a complaint, transparency with that person is the best policy to have as your default response. It is good to hold your hands up when you get something slightly wrong. Acknowledge their concerns and then tell them what you have done to adapt your processes, maybe a new policy you've introduced because of their complaint, or even inform them of any training that will now be done to give your staff more support. This kind of transparent response is very reasonable and very in keeping with data protection law. You can also be proactive in this as well. For instance, let's say you won't be able to fulfill a subject access request on time and you're fast approaching the deadline. The best practice to do is to manage that person's expectations and let them know in advance. This allows you to approach it reasonably. You can tell them you'll be able to provide a part of their request on this date and will do so all the while informing them on when they can expect their full subject access request to be completed. Maybe even ask if there's an area they want to be prioritized so you can focus on providing the most important information on time. Although they would still be able to complain, this kind of proactivity looks far more favorable. Then most importantly, when the complaint has been addressed, take it productively and look at what went wrong and anything you can change. Essentially, make sure you're always learning something and improving your practices. Maybe while completing a subject access request, you notice that you're having to go through far too many emails that did not serve a purpose to still be held onto. If that's the case, then consider to shorten your retention periods for them. This will help you when handling any future requests and help protect your business by continually improving your practices.
If you're unfortunate enough to suffer a data breach, your top priority should be to contain and mitigate the breach. This is to help protect the individual or individuals from high risk of detriment. Try not to become overly focused on a 72-hour time frame to report into us, as not every breach is reportable. A breach will be considered reportable when the level of detriment is above inconvenience, nuisance, stress and/or anxiety. That is a level of significant enough proportion to cause a high risk to people's rights and freedoms. 72 hours starts when you become aware of this higher level of detriment. What you may find is once the breach is contained, it may not be reportable. For example, accidentally sending an email without using the blind carbon copy function to a mailing list, thus disclosing each recipient's email address. If you can confirm it has been deleted, and depending on the context of what was actually in the email, you may find it is not reportable. But make sure you keep a record of the data breach itself and the details of what happened and the actions taken to mitigate and contain the breach.
Fantastic. So that moves on to our last tip, where to go for help. If you ever need help, guidance, a second opinion, or even someone just to talk through your data protection issue with, then do not hesitate to contact our live services area. Our services are entirely confidential, so there is no need to be concerned because fundamentally, we're not here to catch you out in any way. Our priority with small businesses like yourselves is to get you engaged with data protection law for your own business's benefit. We are here to offer you the help and guidance to get towards full compliance. We're not here to be issuing you with fines or penalties because such fines are commonly reserved for only the most serious breaches and are rare. You can even look at this yourself on the action page of our website. But while I'm recommending places to go have a read of, I strongly recommend you visit our SME website hub, which you'll see a link to on your screen now. On there's guidance that's been tailored for organizations of your size, and I would really recommend this to be your starting point if you ever need any support. There are some very easy to use self-assessments and some useful FAQ pages there for you to explore.
You can also apply for an informal online advisory checkup through the Get Support pages of our SME web hub. Advisory checkups are tailored to your organisation's size and the type of work you do, with a particular focus on areas that are important for your customers, volunteers, members, and people working alongside you. They're done on a one-to-one basis, and you get a report at the end giving you, giving you some recommendations to help make sure your data protection practices more effective and efficient. If you're interested, you can apply for this online through our SME web hub. That wraps up the tips for today. Hope you've enjoyed them. And remember, any questions that you have, send them through to us now, and we'll do our best to answer them at the end. I will now pass you over to Olivia, who will go through the registration process and a few more pointers on registration itself.
Thank you. Okay, so I talked in our part one session about what it means to be registered with the ICO and how to register. Your registration with the ICO is a key part of your data protection basics as an SME. In this session, I'll quickly summarize what you need to know about fees and registrations and go through some information on data protection officers. When you register and pay a fee, you're listed on our searchable register of fee pairs, which is on our website. For most small organizations, the fee is £40 or £60 a year, whereas large organizations pay £2,900. You can check if you need to pay and the amount on our website using the self-assessment tool. You can save time and money each year by paying by direct debit, which also deducts £5 from your fee. The registration is part of the legislation which we oversee. The fee is used as part of the regulations to fund the work that we do. Not every organization has to pay the data protection fee. The most common exemptions for SMEs would be 1, staff administration, so payroll, national insurance, identification, HR records. I mentioned this in part 1, but to give you an example of where this would come into play, this would just be the basic records held specifically for admin purposes. You would not need to pay the fee if you only hold staff records. For example, companies working strictly business to business do not require registration, as they would not be handling information on members of the public. 2, advertising, marketing, and public relations, so newsletters, adverts, social media. Again, I mentioned this in part 1, but I thought it would be worth highlighting in a bit more detail that holding customer information for direct marketing is exempt. If you have a monthly email, for example, and send this out to your clients, this alone would not require you to be registered. Most organizations advertise directly to their clients or customers. Only using personal information for marketing purposes would not require registration so long as you make the decisions on how this is done. 3, accounts and records, so tax information, invoicing, communication to confirm appointments. Organizations which only hold information for accounts and records purposes do not require registration. Producing invoices for your customers on its own would not require registration. This would also apply to something like a holdings company. Only holding information for your organization's tax purposes would not make you required to pay. And the final one, 4, processing without an automated system. So this applies to those who only hold paper records. Old school processing is entirely exempt from the need for registration, as it is purely focused on electronic processing, which most organizations are doing in a digital world. If you only hold information on your customers on paper, that would make you exempt from registering. For example, a plumber might hold information on staff, as well as sending out information on their services, and of course, tax information. This would all be exempt from paying the fee, just the same as it would be if they only held paper records. But they'd be taken out of the exemption if they have a dash cam in their vehicle. Processing like this, above and beyond those core business exemptions, would require them to be registered. We get a lot of SMEs calling us asking about registering a data protection officer. It's worth noting that DPOs are a legally defined position within an organization, can be required or voluntary, but they're not ultimately responsible for the information being processed by an organization. Generally speaking, a DPO would not be required unless your processing includes any of the following. So processing is a public body, which would be any organization funded entirely or partially by the taxpayer, an organization that is dealing with large-scale special category data like an NHS hospital, or for organizations that process large-scale tracking, for example, a retail company that has loyalty cards. For any further queries to do with registrations, please visit ico.org.uk/fee. That's the basics of registrations. Now I'll pass you over to Dan.
Thank you, Olivia. So that brings us to the end of the session today. Hope you found it useful. Hope you found the tips handy, and will do in the future. So, of course, please keep in touch with us. You can find us on all the social medias, social media channels. Excuse me. You can subscribe to our e-newsletter on our website, and you will certainly find our SME web hub useful as well. ico.org.uk/hub. Okay, so we've been inviting questions throughout the presentation, and we've got a few in, several actually, lots. And we're going to kick off with one that there's been a lot of interest in. So we ask our staff to provide a couple of emergency contacts, name, email, phone, address, to contact if something happens to them. Yeah, it's fairly common practice. Do we need to get permission from the contact to hold their data, because it's provided, of course, by the employee? No, basically. This is a common practice. We're not, as Flynn said, data protection law. You should trust your instincts, basically. I'm sure for years, you've collected this information and not asked for consent necessarily, and GDPR doesn't change this. Myself and Dave touched on using legitimate interests as a lawful basis in the first seminar, and we mentioned how the interests can be not just the organisations, but sort of other third parties as well. Ultimately, having the emergency contact details for emergency contacts of your members of staff is in everyone's interests. So it's certainly something you can justify under that basis, and without necessarily having to ask for consent. Moving on, someone's asked what exactly would count as an international transfer, and I know Flynn touched on the fact that one of your employees can work abroad without this being an international transfer, and the key there is that your employee is not legally distinct from your organisation. So an international transfer is a transfer from a data exporter, so let's say that's your organisation within the UK under the UK GDPR, to another country, basically to a receiving organisation or entity which is legally distinct. Those are sort of the conditions for an international transfer. And if it's another country that isn't subject to an adequacy decision or adequacy regulations, then you may need to consider, or will need to consider, implementing appropriate safeguards. So moving on, we've got a question on the scenario actually that Flynn went through. So Flynn, would you like to address that?
Yeah, so it looks like the question is saying, is there not an expectation for that customer to prove who they are? Again, this is very kind of commonsensical, depends on the situation. If they've rung in and you've interacted with them before and you know them over the phone, then no, asking them to provide a copy of their passport or some kind of ID potentially is quite obstructive, isn't it? If you do need it, it's come from an email address maybe you don't have on record, or over a phone number you don't recognize who's speaking, then yeah, maybe it would be reasonable. But the way that you prove ID, it's not as always strict of, we need a copy of the driving license, we need a copy of the passport. Can they identify things on the account with you? Can they give certain numbers back to you? Just, your standard kind of security checks. There can be ways to confirm ID. So again, it's flexible and it's up to you to justify. If you're dealing with particularly, maybe let's say you're a law firm and you have far more sensitive information, then yes, I imagine probably asking for passports and copy of passport, something like that would be far more appropriate due to the sensitivity of the information. So it just goes back to trusting your instincts, really. And if it seems wrong, it probably is.
Exactly. And as we talked about security in the first seminar, it's a risk-based approach. And as Flynn said, it depends on the information you're holding and, how what's the risk is associated with that. So the next question we've got is about sort of obtaining personal data from readily available sources such as LinkedIn, and if you obtain personal data from these sources, would you have to basically inform the data subjects? And yes, you would ultimately. So the right to be informed is a right in data protection law. And if you look at our guidance on this, it states clearly that if you are obtaining personal data indirectly, so not directly from the person, you need to inform them that you have obtained their data basically within a calendar month, or at latest, or at the first point of communication with them, whichever one comes first. So no, you can't basically just, as much as it's publicly available, you can't just go around and collect anyone's information that you want and not tell them that you've been doing so. So moving on to the next question, and this one's about sending birthday cards. So Flynn, would you be able to cover this?
Yes, so it's asking adaptation on what Dave spoke on right at the beginning of the workshop. Rather than sending a card, the manager wants to send the employee flowers, which is very nice, using an online flower provider. But when they're passing personal data, are they doing it unlawfully to this third party? And the answer is it depends. More than likely, no. Again, you've just got to look, how are you going to make this processing lawful and fair? So I imagine an appropriate lawful basis for this would probably be legitimate interest. There's a legitimate interest in you sending this to help them, well, to just be nice to them, really. And is there any kind of privacy impact to them because you're doing this? It very much depends on the context. So it's always just about doing that balancing act and that legitimate interest assessment. Maybe if they've done it completely gung-ho without any consideration, potentially, yes, it could be. But as long as there's careful consideration, you can justify the action of the processing, that the legitimate interest was valid, then that would be quite a reasonable way of processing.
Precisely. Thank you, Flynn, for that answer. Moving on, we've got a question about appointing and do we need a DPO? If we process criminal data, as we provide services linked to probation, we process data for approximately 2,500 data subjects in this area, and a further number through our other support services outside Ministry of Justice work. So Olivia, would you be able to give a bit of advice on whether or not an organisation might need a DPO here?
Okay, well, it sounds like it might not need a DPO just due to the fact that we would normally say large scale, about NHS hospital scale. So it doesn't sound like there's enough data subjects to really fall within the requirement to need a DPO, although we do ask that you take the self-assessment as well, just determine whether you would want one on file. Of course, you can always voluntarily add a DPO as well to your registration.
Okay, cheers, Olivia. Thank you. Time for a couple more questions, and there's one here about SARS, I believe. So if someone asks for all the emails in which they are subject and the IT search results bring in a high volume of emails, how would we approach this? And I think there's a related question. I went back to them, said they wanted everything on them. They worked there for 7 years and their email address was used in a lot of communications. I've written to say it will take longer than 30 days and explain why. What do I need to do if it's not feasible to complete in 3 months? So with no dedicated staff, a lot of detail there. Dave, do you think you could give some answers on that?
Yeah, I'll have a go at that one. Basically, I can see there that it looks that you've tried to get the individual to reduce the scope of the request. One thing that you do need to be careful of is when you're doing a SAR request and when you're looking for information like this, is you need to know what you're discounting and what you're not discounting. So what actually is personal data, what information is information with regards to that individual. So things like newsletters and things like that, that's not personal information about the individual, that's information about you as an organisation. So you don't really need to look at information like that. Anything again that's around Robin that everybody else would have, again, you don't need to consider that information. It's information that's about individual, which names individual and can be clearly seen as being data about the individual. You can always still go back and explain to them the circumstances and that you're doing everything you can to deal with it, and ask them if they can narrow the search down a little bit. If there's anything that in particular they are looking for, as was mentioned in the sessions earlier. So if it is a particular piece of information they're looking for, or a particular time period that they're looking for, again, you can try and narrow the search down, but ultimately you do need to try to deal with the request. The other thing to do as well, once you're getting into the long time frame, you need to look at trying to disclose some of the information that you've already got. So looking at, again, this goes back to the session before, if you've got some information already, then by all means, let them have the information that you have up to that point. Explain to them what you've got and how long it's taking because of the circumstances. Ultimately, if you aren't able to deal with the request within the time frame, the individual is obviously within their rights to bring a complaint to the ICO. We will look at what you've done in those circumstances to try to deal with the request as much as possible within the remit of the law. So although a complaint may come to us, it may be the case that we will give you further advice as how to deal with the actual request itself. It may be that you're digging a little bit too deep into this request, and therefore picking up more information is actually required on the subject access. I hope that helps.
Cheers, Dave. That was really helpful. A lot of information there, a lot of good information. So this may be our last question, we'll see. And this one is about how can we mitigate risks related with sub-processors of online services? Many SMEs don't have the option to find a commercially viable alternative to established providers, e.g. Google, Microsoft, Amazon. Flynn, do you think you could give some insight into that?
Oh, I'd love to, Dan. Yeah, so essentially, I imagine it's talking about security risks, really. I think it's just read the terms and conditions and what you're signing up for. And if you have any questions, definitely push back on it. Don't be afraid to stand up for yourself and send those questions that you have to those processors to get any kind of concern or query that you have specifically. Get that cleared up with them and then see what they get back with. And if you're still not happy, give us a call.
Yeah, precisely. Cheers for that, Flynn. I think this may be our last question. We'll see again if we have time for any more. So what is the best way to redact efficiently from paper files? Tried so many things. So in terms of this, I suppose it's important to remember that there's no specific requirement for you to provide full documents, full papers, files, or anything like that in response to a SAR. A SAR entitles someone to purely their personal data in a commonly accessible format, generally speaking electronic. They can of course request it on paper as well. So if it is, say, a paper one where you are having to provide paper documents in terms of redacting from those documents, if you're not satisfied the technique you're using is going to successfully redact the information, then you will need to find another one. Like I say, if you're not able to do that effectively from paper files, it may be worth reconsidering the way you are actually providing that information to the person.
Can I quickly jump in, Dan?
Yeah.
I think it's really important to say as well, if you do it the old-fashioned black pen marking it, be very careful when you're doing it on printed, because sometimes under a light, that information can be seen even with a black redaction. So just be wary of that. So before you go through the whole SAR doing it, just try it, test it, see if it works.
Exactly. You may be able to scan the document and redact it electronically as well, even if it's paper to begin with. Anyway, I think that's all we've got time for. So all that remains is to thank you very much for attending this session and the part one if you came to that as well. We hope the tips and guidance has been helpful. And like I say, visit the SME Web Hub if you need any further guidance following on from today. Thank you.